Yes, counsel. Good morning.
Good morning, Chief Justice, Justices of the Court. Good morning. May it please the Court, Kevin Nugent on behalf of the applicant for further appellate review, the appellee, David Demonico. What we are seeking, Your Honors, is that Justice Henry, the trial judge's decision, be affirmed in that his finding that the mediated agreement is not enforceable be affirmed. Briefly, this is a matter that was filed in the Middlesex County Superior Court between two siblings and the husband to one of the siblings. The matter proceeded through litigation and a mediation. The conclusion of the mediation, there was, on the plaintiff's side, alleged to be a settlement. The plaintiff sought to enforce that.
Excuse me, I'm sorry.
Yes.
You're saying there was no settlement? There was no settlement agreement?
Correct, Your Honor, as a legal point.
Well, I'm saying, was there a settlement agreement?
No, because as a legal point, there can't be a settlement agreement absent capacity.
Okay, so you say it was a signed agreement, but there was a lack of capacity, therefore it's not legally binding.
Correct, Your Honor.
All right, but there was an agreement, whether it's legally binding or not.
Correct, Your Honor.
All right, and the lawyer for the parties that are now contesting it signed the agreement on their behalf and with full authorization?
That's the state of the record, Your Honor, yes.
Okay. And when was that authorization given?
October 2006.
At the mediation? After the mediation?
The record is devoid of any evidence of that because of the confidentiality requirements of mediation and attorney-client. The record specifically is devoid of that.
Well, we're talking capacity here, but we're talking about someone who was very emotional about on the day of the mediation, or at some point during the mediation became very emotional.
Correct.
I mean, this involved litigation with her sister.
Correct.
It involved her home. It had been going on for several years, I take it?
Yes, Your Honor.
And the parties, the terms that were being negotiated required the sale of the home. That's
Yes.
an emotional situation. It's understandable.
Correct.
All right, but she authorized her attorney to sign the agreement at some point. Was she had no capacity then?
Correct.
Okay, but we don't know when that was.
We know there was no capacity to enter into the agreement. Justice Henry held a hearing and specifically found that. So there was no capacity at the time.
At what time?
At the time that the agreement was entered into.
So there may have been capacity at the time she authorized her lawyer to enter the agreement, but there was no capacity at the time the lawyer signed it?
No, there was no capacity at the time of the alleged authorization. The authorization is alleged to have occurred from the record at the conclusion of the mediation as she is leaving the mediation.
As she's leaving, she authorized the lawyer to sign the agreement.
The record's somewhat unclear on that, but that appears to be the case, and he goes back and enters into a mediated agreement.
And what about her husband, who also represented by the same lawyer?
Correct.
Presumably at the same time authorized their joint attorney to enter the agreement?
Presumably. That is the state of the record, Your Honor.
And he wasn't in an emotional, he wasn't incapacitated in any way?
There is no discussion of that either way in the record.
And she's got, you concede there's not a question of mental illness or mental defect here, or dementia or any of those kinds of conditions. This was just, she was emotional, very emotional.
Well, no, I don't concede that. I think that there's a developing body of law and a developing medical understanding of what mental illness and trauma to the head and other trauma, in that you can slip in and out.
She had a trauma to the head?
No, but I said there's a developing understanding of what constitutes capacity in mental illness or trauma, in that one can go in and out such that one having
So was there evidence here that there was evidence here that she had some form of mental illness as broadly defined, or?
No, and I think that's where the appeals court got off track, frankly, Your Honor, because it doesn't need to be. One, for example, and the decision just handed down on August 22nd regarding criminal responsibility, the quote was, one can go over the edge. One can have capacity one moment and not have capacity at the next. One can be criminally responsible in the morning and not criminally responsible at evening for an act. It's a
Well,
decision.
it's a result of a mental illness. Criminal responsibility is a result of a mental illness that incapacitates someone
Correct.
from acting rationally.
At the time.
Right.
At the time. It's different than whether that person is competent to stand trial. It's different than whether that person was competent to drive to the scene of the alleged crime. Capacity is the same analysis.
And we're not talking duress here. We're just strictly capacity.
Correct. In the strictly capacity, every case that has dealt with it in the appeals court and the Supreme Judicial Court, they have affirmed the trial court's ruling, whether that be to find it was capacity or a lack of capacity. The reason being, it's an inherently fact-specific analysis that trial judges are equipped to make. And in this case, the procedural history of the matter was appealed, went up to the appeals court, and the appeals court remanded it to Justice Henry, specifically asking him to make findings and enunciating the standard of law that should be applied. Justice Henry did that. He based it on his notes, his observation of the witnesses at the hearing, in his review of the transcript.
Did your client, so is your allegation that your client was unable to realize the true import of the settlement, or was that it? She was unable to realize that their house was going to be sold and she would have to pay her sister $100,000?
Correct.
She was unable, or was it because she realized that?
Unable.
She was unable to realize that.
Unable to realize the import of the situation. It's different. You know, the court...
But this is going on for years. So we're talking about she's been involved in this litigation for years. These are settlement discussions. She's unable to realize the import of the settlement discussions.
That's correct,
Not
Your
just emotionally upset about them.
That's correct, Your Honor. Your Honor, and there's numerous cases where people participate in things for years and due to circumstances can be overwrought at a moment in time. And this is a case where she was overwrought at this moment, not just emotional, not just upset. That's not what Justice Henry found. Justice Henry found that she lacked the ability to comprehend the nature and quality of the transaction, together with an understanding of the significant consequences. That's what Judge Henry correctly found. And it's not, the appeals court went down the wrong road when they seemed to, you had to find a long history of degenerative or progressive illness.
Or any history of mental illness or mental incapacity.
Don't have to find that at all.
None. Just
Actually, that's correct. And, Your Honor, there can be someone that has a long history of mental illness or degenerative or progressive illness and can be perfectly fine to engage in a contract at a moment.
Understood.
So that, as a matter of fact, in Missouri, they found the cases where the trial judge's ruling was to find capacity. They were both businessmen that had progressive debilitating ailments that continued to get worse after the transaction. In that case, even though they had diagnosed conditions that were medically substantiated, the court found that at the time of the transaction, at the time of authorization, they had capacity. In the cases in the Farnham or Krasner or Sutcliffe cases that all follow, these are all really based on Reed and its progeny, the 6 cases following Reed. It was held that it's the time, the moment, it's a snapshot of the moment of authorization. So in Krasner was only a 53-year-old gentleman. He was a doctor. He was an avid skier. Krasner, at the time of authorizing or entering into a 3-year lease agreement, did not have the capacity.
Well, you're articulating pretty long-held principle about the moment of incapacity or capacity. Doesn't have to be, just for that moment. But it's never been applied in the factual circumstances that you're asking us to address it, right? That is, this is the only moment, not before or after, not coming out of an illness, not a subsequent. This is it. Just at this very moment, a lot of circumstances in which we can't know about, can't ask the lawyers, can't ask the mediator, can only ask the person she was arriving and leaving with. And that's what you're asking us to now decide, just to clarify. that's what's so different about this case. You could just slip into this cognitive state of incomprehension, not ever having experienced it before, no trigger except being there and about to sign an agreement that's really upsetting.
Respectfully, the short answer is yes. The longer answer may be that's what Judge Henry was charged with analyzing. Now, at the trial setting, if I were to try a case, would I like 6 medical doctors in my stable of witnesses and stacks of medical records? Perhaps. Perhaps it would lend weight to the analysis. This particular litigant was not armed with that. She suffered a lack of capacity at this time, and she was charged with convincing the trial judge of this through testimony. He analyzed her he made specific findings that he found her credible, and he found her husband credible. And based on that, he did find a lack of capacity at the moment of authorization. And it can be a one-time thing, respectfully. It can be a one-transaction occurrence.
Well, but doesn't that set the stage for cases in the future that without any history of mental illness, without any diagnosable mental illness, somebody can do a dry run on any kind of a case just by going in and crying and sobbing and leaving in the middle? I mean, it's something that's kind of easy to stage. How do we know that it's real, absent some kind of at least a medical diagnosis that this person was suffering from a mental illness?
Well, the trial courts are charged with this every day, Your Honor. Respectfully,
well, it's going to become an everyday occurrence.
I disagree with that. I think frequently the forewarnings of these becoming everyday occurrences or the end of contract law as we know it, if those warnings have always been without merit. I think that this will be a very rare instance in the future, just as it is now. I think that there's a dearth of case law on it. 6 cases since 1911 that I saw, and I think there's a reason for that. It's not a common occurrence. But the trial courts are charged every day with analyzing credibility in self-defense cases where there's no videotape witness, in cases of domestic allegations between a husband and wife where there's no physical evidence. We charge juries and judges with that.
But here the specific issue is incapacity.
Correct.
And hasn't that always been defined in terms of a mental illness or some sort of a mental disease or defect?
It has not always been defined that way. The courts talk about, or in holdings, they look to evidence of that at times. But in Meserve and DiMatteo, Mr. Daggett and DiMatteo, who sold his marshland, had mental illness problems, and he had a progressive debilitating condition, but he had capacity at the time, which is why the trial judge was affirmed. The same with Meserve. Mr. Dowling, when he leased his land to Jordan Marsh, had capacity at the time. So even though he was suffering with issues,
mental illness is not enough. I mean, mental illness is usually, I mean, the point, I think, is that evidence is required, but it may not be sufficient to establish incapacity.
It's not required, and it's not a question of whether it's enough or too much or a little.
It's not required because you say it's not required, or we've said it's not required, or we've always referred to it in all of our cases.
The cases do not require it.
They just talk about it as evidence.
The cases have had evidence of it. There was no specific evidence that Dr. Krasner had a mental illness at the time of entering into the lease agreement.
Is there a case in which we have discussed and upheld a finding of incapacity in a circumstance where there has been no other manifestations of a mental illness? I mean, I'm thinking of divorce agreements where I think this has come up, and we've rejected those pretty routinely.
Appeals court cited a case, I don't think it was on point, Grinlinger versus Grinlinger out of the probate and family court, and that case was misplaced because that one was a morning of a trial. Mr. Grinlinger signed a divorce agreement. That agreement then, as frequently as the case in probate court, as Your Honor knows, was memorialized with a typewritten agreement that basically stated the same thing in a neater fashion. He signed that as well, and that was a 60B motion, and the court affirmed the trial court's unwillingness to exercise its discretionary authority in that case. But the court
You mean unwilling to exercise discretionary authority to set aside the contract?
set aside the judgment, yes. That Mr. Grinlinger signed actually 2 separate documents stating the same thing, first a handwritten, then a typewritten. And he was sleepy and fatigued. What's interesting, and I found it was in the Krasner case, is the court held specifically that if the trial court had found differently, had found opposite as it did, the court would have had no trouble affirming the trial court in that circumstance as well. In that there's what is replete through all these cases is the willingness of the appellate courts, whether it be the appeals court or the Supreme Judicial Court, to look to the trial court judge as the...
Remind me in Krasner, what was the issue?
The issue was Dr. Krasner entered into a lease agreement with a fellow doctor for office space for 3 years. And Dr. Krasner...
He had a condition, disease which caused premature senility of the brain. So there was a mental condition there of some significance.
There was a mental condition there. There's a question of the significance at the time he executed the agreement. I think that was the litigated dispute because he later retired by the time he...
Can I ask you, have we accepted the restatement of contract second on this question? Let me just read it to you. A person incurs only voidable contractual duties by entering into a transaction if by reason of mental illness or defect he is unable to understand in a reasonable manner the nature and consequences of the transaction. Have we accepted that?
We haven't accepted it other than the court specifically accepted the portion that if a contract is voidable due to a lack of capacity, so to the extent that it calls it voidable, if a contract is voidable due to the extent of due to lack of capacity, then there is no further inquiry needed into whether or not the parties acted fairly, the other party that's seeking to enforce the agreement acted fairly, or the terms were reasonable. So the record in this case is somewhat, there's a dearth of evidence in the record on whether the ultimate transaction was reasonable or whether the other party acted fairly in attempting to enforce it. But we respectfully don't need to get there because of that adoption that the contract is voidable. There's no further analysis.
Right.
Thank you.
Thank you, Your Honors.
Good morning, Justices. Christopher Driscoll here for appellant below, Miss Frances Sparrow. May it please the Court, Counsel. Susan Demonico simply had a change of heart following a second voluntary mediation that was initiated by her and her husband.
Let me be clear here. I mean, there are two issues here. One is, was the judge clearly erroneous in finding that she was mentally incapacitated on the day of the mediation? You say that it was clearly erroneous?
I say the judge erred by not making that finding, ignoring controlling case law decisions of this court that require, respectfully to counsel, a showing of mental illness or defect.
I guess that's my point. So do you agree, and let's put aside the issue of the legal finding. He says she was incoherent, slurring her words, out of control, and unable to think rationally on the day of the mediation. Do you agree that there's evidence that supports that and that that's not a clearly erroneous finding?
That evidence can support an inference that there were cognitive issues, Your Honor.
Try my question. Was the judge clearly erroneous in making that finding?
I would say that yes, because there was absolutely no evidence of what her mental state was when she authorized settlement. There was no medical evidence. There was no discussion at the hearing as to the terms that were agreed to, whether this lady understood them. Okay. No questions.
So you're saying that no matter how irrational, no matter how out of control a person may be, the contract that person signed should still be enforced unless there is evidence of mental illness. That even if the person indeed is incoherent, out of control, and incapable of thinking rationally, that a contract that person signed should be enforced unless there is evidence of mental illness.
That is what our cases say. This court adopted the restatement standard in the Krasner case. And
adopt that standard?
Cited with approval in Krasner, Your Honor. The mental illness, mental defect standard, successful cases in the past have all required, there's all been medical evidence supporting a diagnosis, mental illness, and mental defect.
But there's some interesting language in some of the cases. Sutcliffe, for example, an inability to realize the true purport of the matter in hand is the equivalent of mental capacity. Well, isn't that what we have here? The inability, the judge found she was unable to realize the true importance or purport of it. And isn't that the equivalent then of mental?
Your Honor, that language was taken in the context of a decision where an elderly person afflicted with epilepsy for a decade made a one-sided transaction in favor of her brother. There was also a finding of undue influence in the case. I'd suggest to Your Honor that it's a distinguishable decision.
Okay, so let's imagine that a person is incoherent, out of control, and incapable of thinking rationally, not because of mental illness, but because of drugs or alcohol. Would you say that the contract must be enforced?
Depending upon the context, Your Honor, supported by medical evidence, minimally.
Well, you're not going to get blood alcohol tests in this type of a case. So you're saying that there must be a blood alcohol test or a breathalyzer done at or about the time of the contract for that to be?
No. To answer Your Honor's question more directly, there could be an extreme set of facts, conceivably, not presented here. This is a day-long voluntary mediation initiated by them.
But then you recognize that there may be something other than mental illness, which may be temporary, which may cause the contract not to be enforced.
Yes, a factual context can be imagined, not presented here, Your Honor.
Okay, so I guess my question, though, is the issue is, do we focus hard on whether it was clearly erroneous, or do we simply say the judge was entirely accurate in describing her incoherence and irrationality, but that is irrelevant because there's no evidence of mental illness? That's what I'm trying to sort of sort out here. Because they're two different questions.
I'm sorry, Your Honor. Would you repeat?
Okay. One question would be, was the judge clearly erroneous in making his findings? Okay. The second is, the judge was not clearly erroneous. The judge was entitled to make those findings based on the evidence, and indeed, we can accept that she was incoherent, out of control, and incapable of thinking rationally, but that is irrelevant unless there is also evidence that the reason for her irrationality is mental illness. Are you saying one, or are you saying two, or are you saying both?
Both.
Do you know whether intoxication is recognized in the Diagnostic and Statistical Manual of the American Psychiatric Association as a mental defect?
I don't, Your Honor. The requirement of medical evidence referenced by the appeals court is a necessary safeguard to prevent exactly what happened in this case, the whimsical application of the defense in a scenario where, in the totality of the circumstances, the conclusion is inescapable. The woman had a change of heart after.
You say that, but we've got a very smart judge doing an evidentiary hearing who says that's not true. Why should we not give deference to his findings that it was not simply a change of heart? I'm sure you argued it before the judge. The judge didn't buy it.
He didn't, but the judge never issued findings as to what the cause of the upset was. I'd suggest to this court that it was exactly her absolute understanding of the agreement that led to the emotional outburst, if you will. This is a long-standing fight between two sisters who don't speak to one another, fighting over the family home. I'd be surprised if she wasn't emotional.
Yeah, you're saying which was not caused by mental illness or defect, but by virtue of the ultimate agreement in the case. That's what caused her to be so upset.
That's exactly right. Her grasping it, showing cognitive capability, grasping the agreement. She's lived in this home most of her life, Your Honor. She's going to have to move out of her family home. She's been fighting with her sister. They haven't talked in years. I couldn't imagine anyone not becoming upset in that scenario.
Well, I suppose, but I don't know, that circumstances might cause such overwhelming emotional reaction that it may constitute a temporary mental illness or disease or defect. It might. I don't know the answer to that. But in any event, if it did, there was no psychiatric testimony in this case to establish that point.
There was not, Your Honor. No medical evidence whatsoever. Records, certainly no testimony, nothing. Emotional upset, trial judge bought the argument that it constituted, in this case, lack of capacity. Does not square with the prior decisions, appellate decisions in this Commonwealth. There's 3 cases that have accepted the defense: the Krasner case, the Sutcliffe case, and the Farnham case decided below in the appeals court. All of those cases involve diagnosed mental illness or defects right following the restatement standard that materially impaired cognitive function for a period of time. The appeals court was concerned with this lady's claim that her capacity was narrow just to the mediation that day. Voluntary mediation, don't have to be there. No evidence of any issues or problems functioning beforehand. To the contrary, middle-aged woman managing a household, running a household on her own. No evidence of any issues or problems after the mediation, Your Honors.
Would it matter if there indeed was a psychologist who had testified here who said, as Justice Spina mentions the possibility, that the emotional content of this was so overwhelming that it rendered her essentially temporarily, for lack of a better word, insane? That basically this was an emotional overload, and that, as a matter of psychological expert opinion, she was not capable. Would that change your view?
It would certainly have helped the presentation. That's medical evidence of cognitive issues that we're getting warm. Our cases emphasize mental illness or defect for a significant period of time, a material period of time, not a transient emotional state, Your Honor.
Well, that's what I'm trying to sort out. Are you saying that a transient emotional state, even supported by a psychologist's opinion, is not enough, or that it may be enough if there were to be a psychologist's opinion?
In a particularly good case with fantastic facts supported by medical evidence, that defense could be sustained. We're not even close on this record, Your Honor. Our case law similarly looks at whether the agreement was reasonable in context. At the hearing below, there was absolutely no evidence on this. The agreement, the memorandum of agreement itself wasn't even put in. There were no questions asked of this woman as to its terms, whether she understood the...
But have we accepted, I mean, isn't our law that if in fact there was a lack of capacity, that ends it? It's void or voidable? I mean, we don't then go to look to reasonableness, do we?
No, it's a factor in the analysis, though, Your Honor. It's one of the factors considered.
Well, as I understood it, so it's a factor no matter what. It's a factor. So what does that mean? If she doesn't have capacity, the agreement can still be binding if it was reasonable? Is that what you're suggesting?
No. There's a requirement of capacity, but if you look at the agreement that's struck, and it's plainly out of balance, as the appeals court did in Farnham, if there's an inequitable agreement, a one-sided result, that's a factor in the analysis. It wasn't even addressed in our case. There's absolutely no evidence of it. This woman didn't come in saying, I didn't know I had to sell the house. I didn't know I was going to have to leave. No evidence of the husband suggesting, you're not right. Let's not make this decision today. Nobody forced her to authorize settlement. This was a voluntary mediation. She and her husband initiated it.
Can we assume that the authorization occurred on the day that she had her lawyer sign it?
I think we can assume that, Your Honor. There was no evidence presented on that issue below at all. The sole defense to enforcement was absence of capacity. No claim of lack of authority ever made. The husband was outspoken. He was not afraid to speak at the hearing. If there had been any issues along those lines, I believe that they would have come out.
So what you're saying is we can assume the attorney was authorized on that day by his clients to sign this agreement, right?
Yes.
What do we do in the area of testamentary capacity? If there's an issue that a person was not competent at the time they executed the will, do we require medical evidence?
No. The evidence can be presented by those witnessing signatures, Your Honor. It certainly would be a more compelling, supported presentation.
Yeah, but so in the case of testamentary capacity, you acknowledge that you don't need to show, you don't need to show a mental disease or defect, at least through expert testimony.
That is my understanding of the law, as distinguished from contracting, which we're discussing in this case. Yes, Your Honor.
Why couldn't you do it in this case? Why shouldn't the same standard apply?
Again, to prevent whimsical advancement of a...
Do the same thing with wills. You don't want a will to be presented as a legally binding document.
Yes, Your Honor.
If the
In a
person
will...
lacked capacity.
Pardon me, Your Honor. In a will setting, that's one of the functions of those witnessing, is to assess the mental state of the testator. So that's a distinguished set of circumstances. Our case law is clear. There's never been a finding of absence of capacity, absent minimally some kind of medical evidence. It's not unduly burdensome. Chapter 233, Section 79G, you can just put the records in.
But you also have no case in which it was presented and rejected for that reason. I mean, just it happens that the cases you have all have that circumstance, but you're arguing that that circumstance, therefore, is required. But there's no case where we've said that in the absence of a mental illness or defect, you lose regardless of what the facts may be.
No. Clear statement as such. That's correct, Your Honor.
This is the first case in which that issue is presented.
Yes, and below the appeals court did require medical evidence, which again seems a sensible safeguard in a situation like this, particularly in this case, to prevent whimsy.
All right, thank you very much, counsel.
Thank you.
Take a break.